people waiting.
Yeah, about 6 now. So we're just going to wait here, guys, for a second to make sure that we're actually live before we get started. So I'm still seeing that we're waiting. Oh, there we are, and you'll hear me echo there. Okay, my name is Jamie Owen, and we're joined today by the Legal Aid Society to talk about injunctions for intimate partner and domestic violence. Tunisia, do you want to go ahead and introduce yourself?
Hi, my name is Tanisha Hall. I'm a family law attorney and litigation director here at the Legal Aid Society of the Orange County Bar Association. We're located in downtown Orlando, about a block away from the Orange County Courthouse. I am a UCF grad, graduated there in 19 something.
And a Student Legal Services worker alumni.
Yes, I used to work in Student Legal Services. And then I went to law school at the University of Florida, and I have been here practicing at Legal Aid since 2001.
Tachina?
Hi, my name is Tashina Tucker. I'm a staff attorney at the Legal Aid Society. I did not go to UCF for undergrad. I went to FAMU and I went to Florida Coastal School of Law. I have been doing injunctions for about 1.5 years, and I'm also a family law attorney. I did not go to UCF for undergrad. I went to FAMU and I went to Florida Coastal School of Law.
Somebody have it open. Oh, there we go. My name is Jamie Owen, and I'm one of the attorneys at Student Legal Services, and we welcome you here today to our stream here to talk about this. Our office is a free legal services to students. We help out with landlord-tenant, consumer, and uncontested family law, among other issues, but we do not help with injunctions. So that's part of the reason why we're talking to Legal Aid Society today. There are some resources on campus for people who are experiencing intimate partner or domestic violence, and we do have those listed below, and we'll be talking about them and some community resources later. But I think some people now in the pandemic might be worried that, if they're at home and our court system hasn't really been opened, and might be wondering if they're in one of these situations, can they get help now?
Tanisha, you want to answer that?
Hello?
I think she's frozen. Okay. Something's going on with her computer. Yes, you can get a permanent injunction or temporary injunction. I'm sorry. The courthouse is open with limited access. You'd have to have a face mask for entry. You also have to do a brief questionnaire. I think it's about maybe 5 questions. And also you have to do a temperature forehead scan. But even when COVID was going on, we were still able to go into the courthouse and file an injunction because it would be considered an emergency. And you can file any type of injunction in court in room 310, I believe.
Yeah, 310. Yeah. And I think also all of our community resources are still open and available.
Yes, especially with Harbor House, because we do partner with them. They send referrals to our office as well. They have been working remotely and sending over referrals via email and telephone as well. So those resources are out there and they are open.
And I know here on campus, our Victim Services office and some of the other offices are still available for people who might need assistance. Are you back, Tunisia?
Yes, I'm back.
Okay, great. The beauties of technology. So we were just wrapping up that, courthouse is still open and still doing injunctions. We're still here for you now if you need assistance. So what sort of injunctions are there? I know there's all sorts of different types. If you could maybe kind of go over what's available for someone.
Yeah, so there are 5. You can do domestic violence, dating violence, sexual violence, stalking, and repeat violence.
So maybe could you elaborate maybe a little bit on what each of those are? I know there's different criteria for different ones.
Well, definitely the criteria as far as the evidence to present at the hearing is different for each one. But for domestic violence, that's typically for families who've lived together.
Okay.
You have children together. Dating violence is more of intimate partners who have not lived together, but they did experience some form of domestic violence. Sexual violence is just that. There are different, criteria for that one. Stalking, of course, you have to have 2 separate incidences to prove stalking, and then also repeat violence, which is typically for people who want to file it against like maybe a coworker or a friend or somebody who's not a family or, a spouse.
So like a neighbor that someone maybe had an incident with a couple times.
Yes.
Okay. Sorry, I got my notes here.
Okay.
Because we don't do them. I have to have notes. Can't be an expert at everything.
Right.
We know that, sometimes we run into students who might be in these situations and maybe they've been a victim of dating violence or intimate partner violence or something like that, and they're trying to maybe pursue an injunction. What would you recommend as like the most effective way for someone to prepare for that?
I'll let Tunisia answer that one.
For dating violence injunctions, to get a little bit more specific, the injunction needs to be filed within 6 months of the last time the two of them were together as a relationship. So that 6-month mark is really important when it comes to dating violence injunctions. Same thing with repeat violence injunctions. Repeat violence has to have 2 different acts of violence, and one of those acts have to have occurred within 6 months of filing the petition. So for dating violence injunctions, one, they have to prove that they were actually in a dating relationship. I've gotten injunctions for people who were, I had my most recent one, they met on a dating website. They communicated on the dating website for a month, and then they met in person 3 consecutive days, and she filed an injunction and received one. So just because there hasn't been a 6-month or 6-year relationship, if they were dating for a week or 2, depending on that type of relationship and the intimacy or whatever was expected of a relationship, they would still qualify for the dating violence injunction. What some of our most common ways of proving the violence is testimony. Is most likely petitioner testimony, which is the person who's filed the injunction, versus respondent testimony, which is the person who is alleged to have committed the act of violence or threat of violence. We don't generally have a lot of physical evidence. There's not always a police report or a medical bill or photographs. It is helpful when you do have those items. And one of the most common things we tell people, they want to bring in their phones. They want to show the WhatsApp messages. They want to show the Facebook messages. You don't want to necessarily bring your phone to court with the intention of showing your phone to the judge. Because that means you're putting your phone into evidence. And that means you don't get your phone back when you walk out of court. That phone stays with that judge for a year or 2. What we tell people is if you have text messages and, Facebook Messenger or other social media messages, to do screenshots of them, print out the screenshots, and then we treat those screenshots the same way we would treat putting a photograph into evidence. Another option is too, with text messages, depending on your provider, you are able to have the provider print down all the messages for you. And that's one way of getting it in. I tell people who always want to keep everything on their phone, that is great, but what happens if you drop it in the toilet? What happens if it falls in the parking lot? What happens if it's stolen or lost? Then you're losing everything that you've been saving all of this time. So it's always best to back it up and put it into a separate email account or a separate account onto your computer that's password protected. Because if you reconcile with the batterer, thinking things are going to be better because they've apologized as part of that cycle of violence, they've said they're sorry, they didn't mean it, they won't ever do it again, and you've taken them back, they get into your evidence and then they delete it all, or they gaslight you. They start creating evidence that never happened, or they start making you seem as if, or telling people in the public that you are the one with the problem, or that you're mentally unstable. So when it comes to evidence, just don't be concerned if you don't have anything other than your word versus his word. It's up to the judge to determine who's the more credible witness and whether or not there has been an act of violence or a threat of violence. People want to bring in their neighbors, their roommates, their family, their friends. That is fine to bring in witnesses, but remember, the witnesses have to testify to what they saw with their own eyes and what they heard with their own ears. They can't testify as to what one person told another person told them. They can testify as to what one of the parties to the case, the party that's, if the witness is here for the petitioner, they can testify as to what the respondent told them, because that would be an out-of-court statement by the respondent. They can also testify as to what they heard the petitioner say, if the petitioner was screaming or yelling, or it was actually in the moments of the threat or the violence or immediately thereafter. So those are some of the ways. For voicemails, record those onto a thumb drive. The courts don't have CDs anymore, so you can't necessarily burn it into a CD. Record it onto a thumb drive. And right now with COVID-19, a lot of our hearings are virtual, even our domestic violence injunction hearings. You still go into the courthouse for the hearing, but we're set up in separate rooms. The petitioner and the petitioner's attorney, or if the petitioner doesn't have an attorney, they will have an advocate there from Harbor House, which is our local spouse abuse shelter. They are set up in one room. The respondent and the respondent's attorney, along with deputies, and there are deputies in all the rooms, are set up on a different floor of the courthouse. They're not even anywhere near the petitioner at that time. And then the judge is yet into another room, most likely the courtroom or chambers, and facilitating the hearing from there. So you want to make sure that if you have the evidence, you're able to present the evidence. And if it's on your phone, you get it off your phone. And if you have witnesses, they're actually there to testify as to what they saw and what they heard. Tashina, you have anything to add to how to prepare for the hearing?
Summed it up quite nicely.
And then also
I'm sorry, go ahead.
Also, with all the hearings, I always like to start with a petition. Always have your, when you're writing a petition, make sure you put as much as you could in there, that everything is detailed. And if after you submit the petition to the court, something changes, let the court know that at the beginning of your hearing. There are a lot of times in your stay away provisions, you're telling the court that you don't want the respondent to come near your home, near your school, near your place of employment, or near your mom's house. If any of those addresses change in the 15 days between the day you file your petition and the day you have your return hearing, or the 120 days, because remember, when you're filing a petition, like any other civil proceeding, you have up to 120 days to have that person served with that petition before it would be dismissed for lack of service, or there would be a hearing determining whether or not to extend the service period out further. So if any of your stay away provisions have changed, address that up front. And if any new allegations or any violations have occurred of the temporary order, if a temporary order was put in place, let the court know that. And then when you're ready to frame your testimony, you're not going to be able to read from notes. The judge is going to ask you if the stuff in your petition is true and correct, and you're going to let them know if anything needs to be changed, or if not, yes, it is true and correct. And then you're going to go into talking about each of the acts of violence or the threats of violence, and be specific with the time, date, and location. All those are important for different reasons for the judge. The judge is looking at venue, judge is looking at jurisdiction, the judge is looking as to whether or not an act of violence or threat of violence actually occurred. And so as much of a picture as you can paint for that court, the better. We want to know what happened to you, what was going on in your mind at the time it happened, what led up to what happened, and how did you feel during and afterwards. We want to let that court know that this actually harmed you. And if they don't give you this protection, they don't give you this order, this could really happen again.
So I guess maybe to kind of backtrack a little bit is basically we're talking about someone who has been a victim of violence in different categories like we went over, and we're asking the court to help them and give an injunction. And if they do grant the injunction based off the different criteria, which we kind of talked about, what's the effect of that?
All right, and then I'll let Tashina talk about the effects, but I just want to remind people too who are from other states that when we're talking about injunctions, we're talking about injunctions for protections against these different 5 types of violence. You may know of it as a protective order or a restraining order. Or here in Florida, we're talking about injunctions or injunctions for protection.
Goodness, so sorry, my phone is going off. For the effects of the injunction, if you have an injunction entered against you, it's public record. So if you're going up and you're going for a job or they have to do a background check, it will pop up on your background check and it could prevent you from getting that job. In certain jobs, especially dealing with children, I had a case like that where we had an injunction entered against the husband, but it prevented him from continuing to work because he worked with children and he felt as though the parents would not want to continue to come back and support his business because he has an injunction entered against him. Another thing is you cannot possess a firearm or ammunition when you have an injunction entered against you. It's a lot of issues with that. I do have a client now whose husband has an injunction against him and he wants to keep his firearms, but you can't because you have an active injunction against you.
And then there might also be consequences if the person doesn't abide by the injunction by staying away.
Yes. Yes, they could violate the injunction. And if that does happen and the respondent does violate the injunction, I would suggest that you contact the police and file a police report. And then also after you do that, you go to the clerk of court and file an affidavit of violation of injunction. And then what's going to happen is they're going to forward that affidavit of violation to the state attorney for prosecution.
So there could be potentially criminal penalties for that.
Yes, as well as civil, because you still have the judge that issued the permanent injunction that you'd have to deal with as well.
It could also affect their immigration status for those individuals who are still applying for status. And if a subsequent injunction is entered against you, the fact that you had a prior injunction entered against you would give the court the information or the jurisdiction that they need to order you to go to a batterers intervention program, a 26-week program.
And I might have forgotten to mention this at the beginning, but for those of you who are watching live, if you do have questions, you can put a comment down below. I will see it and we'll try to get to those as we go through this. And get so eager to get into it. Sometimes you forget those little housekeeping details. What are some common reasons why someone may not get an injunction? If they go and they ask the court to provide one for them because they've been a victim of violence or they're in a relationship where there has been violence, what are some reasons that might be denied?
Well, some of the reasons that I've dealt with, they didn't allege enough facts and the judge decides it's insufficient evidence to warrant an injunction, or the judge can't determine who's the abuser and who's actually the victim because you have a lot of hearsays, that he said, she said type of hearing. So the judge would just deny it. And another thing I've dealt with quite often is the petitioner just not coming to the hearing at all.
So the person who asked for the injunction has changed their mind and decides not to come to court to follow through.
Exactly. And they could have reconciled with their abuser. So they just decide not to come to the hearing at all. Do you have anything else to add, Tanisha?
Well, yeah, for the petitioner not appearing at the hearing, there could be either the reasons that they did not want to move forward. They could not get the time off work. They did not get the return hearing date. So they didn't even know they had a hearing. Or they tried to get a continuance and didn't understand that they needed to actually be present and have the court order the continuance before they don't show. Because remember, you have to have, in an injunction situation, you have to have personal service on the respondent in order for the injunction to go forward. And it has to be served by the sheriff. You can't serve it, a private process server can't serve it, your friends can't serve the injunction upon the respondent. So if there is no personal service on the respondent, the temporary injunction, if there is one, or the order setting hearing, is extended for another 3 weeks here in Orange County, because the judges here in Orange County work on a 3-week rotation. And the judge who signed your injunction is the judge who hears your case. So if that respondent has not been served, that hearing could be continued every 3 weeks for 4 months Generally, after the first or second time, they start extending it for 6 weeks instead of 3 weeks. Give you time, because every time you're going to court, you're missing work or you're having to find childcare. Now, a place for children on the second floor of the courthouse does provide childcare for children ages 1 to 12. If you're at court as a witness or a party in a hearing, you can take your child there and sign them up. They'll give you a pager and they will let you know if something's going on with your child. So there are some arrangements for children over the age of 1. So those are all factors that could go into the petitioner not attending the hearing and the case being dismissed. If you have a defense or an excuse, a reasonable excuse for not appearing at your hearing, and you get that order of dismissal, you can immediately request a rehearing. That rehearing has to be done within a short time frame, but you can immediately request a rehearing to see if the court will reopen your case so that you can come to your following hearing. If you decide just not to do it and another act of violence or threat of violence occurs in the future and you file a new petition, you can include all the allegations from your previous petition, because that dismissal is generally without prejudice. That means the judge has not ruled on it one way or another, so then you can bring it into the court later at a subsequent hearing. A second reason a domestic violence injunction, repeat violence, sexual violence, stalking, or dating violence injunction could be dismissed is because you didn't meet the statutory requirement. One of the more important statutory requirements is under sexual violence injunctions is that you've contacted law enforcement about the sexual abuse. And a lot of clients don't know that they needed to have contacted law enforcement for the sexual violence injunction. Another reason some of the injunctions are dismissed are the injunctions filed on behalf of minors. There are different procedures. If the injunction you filed on behalf of a minor is against the minor's parent, or if it's against a non-parent. It could be the girlfriend, the boyfriend, the classmate, the roommate, the neighbor, whatever. There are different steps you have to take depending on when you're filing what we call an OBO on behalf of a minor, when you're filing that type of petition. Additionally, in the state of Florida, you can't just bring a minor to court. Even if the minor is the party in the proceeding, you have to file a motion to permit the minor child testimony and have a hearing on that motion before you bring the minor to court. So some people may not know that, and they will show up to their return hearing ready to have the youth testify in front of the court, only to be turned away stating this child cannot testify today. Either the case will be continued for another 3 weeks or to be dismissed and you have to refile and follow the proper procedures. And then the third reason is sometimes there are allegations of child abuse, but not allegations of domestic violence, if that sounds, if it makes any sense. Sometimes there are allegations of parenting issues or time sharing issues, or an allegation of one act of violence and not another act. And then the court will say, if you feel that child is being abused, to report that abuse to the abuse hotline at 1-800-96-ABUSE. And for those of you who don't know, everybody in the state of Florida over the age of 18 is a mandatory reporter of child abuse and elder abuse. And you can report that abuse to 1-800-96-ABUSE by phone, or you can go online now and submit abuse complaints online as well. So those are some of the ways I see it. Or we have all the violence in the world, and the client comes in and says at the end of the hearing, but I'm not afraid of him. He's not going to do it again. And then that just negates everything that just occurred in the hearing. So it depends. It depends on a number of different factors. And since we're dealing with people, no two people are the same. No two situations are the same. The stories kind of sound the same because, domestic violence is a pattern of power and control. And we know those cycle, those of us who deal with domestic violence and dating violence on a regular basis. And so sometimes we can see that, or we have repeat cases. But those are some of the more common reasons I see where cases are being denied.
Might be effective or helpful for one of you maybe to explain like the process for getting an injunction, that you have to file for it. And I know we've kind of touched on it about the service and stuff like that, but maybe an overview of kind of how that happens, so that some of the things you said might make more sense for people.
You want to go through the flow of an injunction?
Okay. So as I said before, you can go to the courthouse in room 310 and file your injunction. And typically what happens is once you file that petition, it goes to a judge and the judge reviews it. And the judge determines right then and there if they should issue a temporary injunction or if they should issue an order setting hearing. Typically, sometimes it could take later that day, depending on what time you go to the courthouse, or the next day for you to find out if you have a temporary injunction in place or if there's an order setting hearing. But after either one of those orders are entered, your hearing must take place within 15 days. And then you have the hearing, you show up. Of course, you're separated. You are not going to be able to see the respondent until you actually go into the courtroom. But since COVID and everything is going on, you won't see him until you go into a tiny room and you view him on the camera. And in the beginning, the judge explains how it's going to work. Every judge is different. They run their courtroom whatever way they see fit. And then the petitioner goes first and they allege all the facts that they put in their petition and they explain, exactly why they need the injunction. And then the respondent will go. The respondent does have the right to question you because he has to confront you because you are his accuser. And then after that, the judge can make a determination on whether they should grant or deny the injunction. But there are a number of ways that hearing can go. The respondent could be served and he just decides not to come. And then that's when you'll have a petitioner only hearing. And it's just you there and you're telling the judge exactly why you need the injunction. He's going to ask you if everything that you put in your petition is true. And then he'll make that determination there. Or you could have the respondent come in and he could just consent to it and just say, well, I don't mind. I won't contact her again. Another instance that would happen is if he has criminal charges pending, most respondents wouldn't want to talk because whatever they say could be used against them in their criminal case, and they just could consent to it. And then the final way that it could happen is if it's contested and you have the full-blown hearing.
And then we created what the Orange County Domestic Violence Task Force a year or two created a waiver form now for petitioners, because one of the safety concerns was that someone would file a petition for an injunction and not necessarily receive a temporary injunction. They would receive an order setting a hearing on their petition, and then that petition and that order setting hearing would be served upon the respondent without any protections for the petitioner.
Right.
So we instated a waiver form now that when the petitioner files their petition, they can waive the return hearing if a temporary injunction is not granted. And sometimes, it's good to have a hearing, even if your temporary is not granted, because you can always give the judge more information and you can expand on the allegations at the hearing, but then you have to determine whether or not you want to waive having that respondent be served with that copy of the petition. Right. Additionally, with your flow of your case with the injunctions, remember when you get to that 15-day hearing, if the respondent still hasn't been served, then it's going to be continued out. If the respondent has been served and does not appear at the hearing, you have a petitioner only hearing where you get to go in as the petitioner and tell the judge why you're there and why you need the protection from the court. And most times, if you have a temporary injunction, most times you get a final injunction. And then it depends on the order setting hearing if you're able to give the judge enough information to meet your burden as to whether or not you would get a final injunction then. Now, after the injunction is granted, a permanent injunction is then entered. That injunction can be, a year long, 2 years long. I've seen some that are 6 months or 2 months, depending on the judge. I've seen some that are 5 years or never expire. So once that injunction is entered, everyone has to abide by it. Now, to clarify, if both parties file injunctions against each other, there can be 2 separate injunctions, 2 separate court cases, 2 separate orders against either party. But what you not have in Florida are mutual injunctions. If a petitioner filed an injunction against a batterer, and then the batterer comes to court and says, well, she hurt me too, I want an injunction against her, the judge is not going to order one against her right then and right there. If the batterer has issues and wants to file an injunction and get that relief from the court, they have to go through the same process the petitioner went through and get a separate court case, separate court number, and go forward. There's just no automatic injunction. And then that leads to some confusion between the petitioners and the respondents too. The respondents, by nature sometimes will say, I'm going to tell the judge you violated this injunction. But if you read the black letter of the injunction, a majority of it is geared towards the respondent, unless there are children involved, time sharing issues, short-term support, because you can get temporary parenting plans, temporary child support, temporary alimony. You get counseling, intervention, all kinds of things as relief in your domestic violence injunctions, dating violence. Each different type of injunction has different types of relief available. And then a lot of times we find where people could have applied for domestic violence injunction, where you get the most relief available, they have filed for sexual violence because it was a marital rape, or they filed for repeat violence because there were two different types of attacks, or they filed for dating violence, knowing that they could have filed for, not knowing they could have filed for domestic. Because a lot of these things, once you start living together, once you're married, or once you have children in common, a lot of these other types of injunctions are escalated up to a domestic violence injunction. So once that final injunction is there, both parties have to adhere to it. But then, either party can come back in and ask the court to dissolve it. Mm-hmm. They can say, things are fine. He successfully completed all the counseling and all the terms that were ordered in the first case. I have a safety plan now. I've been in contact with Harbor House. I don't feel that I need this anymore. And then a hearing will be held to determine whether or not, they're being forced to do it, or so on and so forth. But they can always come back in as a petitioner and ask to have it dissolved, the same way they can come back in as a petitioner and ask to have it modified, like if they agree to a no hostile contact injunction. I personally do not like no hostile contact injunctions because, in my opinion, they're not really effective. They're not really enforceable unless someone's committed another crime and about to go to jail. I mean, it's kind of difficult to prove what's hostile and what's non-hostile. And it's kind of difficult to have someone not come into certain areas without a court order. But if you have a non-hostile and there have been violations, you can come in and ask the court to make it a no contact. Or if you have a no contact, you can come in and try to make it a non-hostile. Or if you had a 6-month injunction, you'd come in and ask it to be extended out for 2 years because of all the violations. So there are different things that you as a petitioner can do. The respondent can as well. The respondent can come in and say, okay, I did my barracks intervention program, or I did my substance abuse treatment, or I'm in rehab, or I'm in therapy, I'm taking my medication. I don't think I need this anymore. They can always come in too as a respondent and request that the terms of the injunction be changed or the length of the injunction be changed. And then there will be a hearing. Because no matter what you do, there's going to be due process. There's going to be notice and there's going to be a hearing. Because with domestic violence injunctions, if you violate it, you could end up in jail.
Kind of follow up with that. Do you think that, sometimes we hear, it's just a piece of paper, or people violate them all the time. Do you think it's effective for someone to go and get an injunction?
I think it's effective for someone to go and get an injunction. What some judges, I know one judge would frequently tell you, the paper is not a bulletproof vest. I mean, if you're dealing with someone who has no regard for the law, mm-hmm. or things of that nature, and they don't have a fear of jail or a fear of court, then those are extreme situations. I would say they're more of the exception than the rule in what I've seen. I've had, over the 18 years that I've been doing this now, almost 19 years that I've been doing this, a handful of people who I feel really had no respect or regard for the law. For the most part, everybody else is afraid of something. And so for those situations where you have an individual who you know has no regard for the law, that's where you talk about Harbor House. And for all these cases, you're going to do your safety planning, but that's when you reach out to the spouse abuse shelter in this county or another county and ask for a safe place to live or transitional housing, because this is a situation where you're going to be in harm's way one way or another. This injunction at least is going to help you when it comes to, if you have children in common, how to communicate about the kids. We have third-party communication tools that we recommend where there's not text messages, telephones, or using the children as messengers. We go through tools like Talking Parents or Our Family Wizard. If we have people with substance abuse issues, we can use things like SoberLink. So there are a lot of different tools that are there to help even those who are blatantly.
Hello, everyone. The phone system black box.
It's always something.
All right, so Tashina, I'm gonna let you pick up from here until I'm sure they're done with their announcements.
I don't even know where to pick up from. That threw me off as well. Thought it was an echo at first.
Okay, so let me see. We were talking about
We're talking about our family.
whether or not an injunction actually helps, and an injunction helps. It definitely helps, and it gives the client some autonomy and it's giving them some control back over their relationship. And for a change, it's probably actually holding the batterer to task and making him or her do things that, you know, he or she would normally, you know, do, because they know that, you know, it's kind of like if they have respect for their mom, you're telling their mom on them or something like that. It depends on the situation. But when you file and when you're doing your safety planning, if you're going to the Orange County Courthouse, you'll file your injunction on the 3rd floor, but there are Harbor House advocates located on the 5th floor in room 520. And there they will give you a lethality assessment that tells you how lethal your situation, how deadly your situation is compared to other situations. And if you're on a higher edge of that lethality scale, they have different options and different, you know, mechanisms that they will put in place in addition to, you know, your injunction to probably help you. Does that answer your question, Jamie, as to whether or not?
I think so.
No, it's not a bulletproof vest, but it is a strong order, and it is registered in the sheriff system, in law enforcement system in Florida and nationwide. And once that final injunction is entered, you can enforce that in any of the 50 states in the United States of America.
And I think one thing too is that, like, for what you were talking about earlier, you can also get some of the other stuff dealt with in an injunction, like the time sharing with children and some of the other stuff, and also like third-party contacts. So can also be dealt with for other family members or someone else who might be contacting you on the person's behalf. On occasion, we run into that. Like, my ex is no longer contacting me, but I'm worried about his mom or someone else, and that also can be helped by an injunction. So.
Yeah, it helps in the sense that it would put in temporary parameters regarding the family, regarding the children, regarding exclusive use and possession of the home. But remember, it's still just temporary. If you want a more permanent arrangement, you have to file one of the other family court cases. And we help with all that here at Legal Aid. We do the injunctions and we help with all of the other types of cases. When it comes to the jurisdiction or the power over third parties, there's one thing to say that we're not going to have to communicate with grandma about what's going on with our child. Another thing to say, grandma's not allowed to call me. This injunction is not against grandma. The court necessarily doesn't have any jurisdiction or any power to make grandma do anything. So if you have an issue with grandma that is threatening your safety, then you may need to go file a domestic violence or repeat violence or whatever injunction against the grandmother. That being said, if for some reason you all agree that grandmother is going to be the one to help do the exchanges, to be the third party exchange, or use the court system family ties. But if you're agreeing to have grandmother or the neighbor or the new girlfriend be the exchange or the conduit, then you write that into the order. And we always say, I always say, make sure you talk to them first before you put them in the court order to say they're going to help. And I always have my clients come with 3 possible people who are willing to facilitate this change, because it's not just, oh, I'll have your kids and he can come get them or she can come get them. It's, I'm going to see this guy every other week, or I'm going to see this guy every 4 days. You know, so some people will agree to do it, and then they realize, oh, this guy really is abusive. They may have thought you were just exaggerating. They're your friends. They believe you, but they may have thought you were just exaggerating, and then they may end up having a situation. So whenever you're volunteering other people to the court to help you facilitate the exchange of your children, please talk to those other people first to make sure they're okay with it and that they can actually do it. You don't want to agree to have the time to exchange your children be every Friday at 6 o'clock, but then you have your mom doing it, but your mom works every Friday at 6 o'clock. So that would be another problem. So those are some of the things to look at.
So I wanted to talk a little bit about some community resources. So I can talk about what's here at UCF first. So there's our office. Like I said, we do not handle injunctions or contested family law. We'd have to refer you, if you're in Orange County, over to the Legal Aid Society. But we do sometimes help with the landlord-tenant situation. So if there was an issue and now you have to deal with a landlord, or perhaps some of the other issues, you can definitely come into our office to get some assistance for that. And we're free for enrolled UCF students. We also have Victim Services on campus, so they help anyone who's been a victim of a crime, including domestic and intimate partner violence. They will provide advocacy, support, can help direct you to resources. So they're a great source of help if you find yourself in one of these situations, and their information is down below, along with our counseling and psychological services office, which is CAPS. You can get some support from them for your mental health, and UCF Cares, which is a care-oriented organization on campus office, tries to look at you as a holistic person and make sure that you're getting good resource, kind of like a social worker, kind of help you navigate all of the many different resources on and off campus that there are. So if you're a student, that's another resource to you. And then if you're off campus, there's the Legal Aid Society. And I know they help with injunctions and family law stuff, but I'm not sure what your criteria is, Tunisia, for helping people.
So we handle an array of civil legal services. They are free to low-income residents of Orange County. If you are a victim of a crime or domestic violence, there is no income restriction.
Okay.
We do family law, so that is domestic violence, dating violence, any of the injunctions for protection, divorces, which are dissolutions of marriage, paternity, time sharing, temporary custody of minors by relatives, so grandmothers, aunts, uncles, cousins who want to have a court order regarding their relative. We do guardian advocacy cases. We generally don't do child support only cases because the Department of Revenue does that. We also handle housing matters, landlord tenant, foreclosures. We handle consumer matters such as collections, garnishments, bankruptcies. You cannot discharge student loan debt. I must tell you all that as students. Be careful with those student loans.
We wish.
They are like taxes. They will be with you until they're paid off or the day you are no longer with us. So we used to handle and help negotiate some of the student loan debt and student loan issues, but you can always just reach out to us to find out. We have different types of immigration cases. We do immigration for about 5 counties. We do a lot of VAWAs, removal of conditional residence and things of that nature. We don't necessarily have the attorneys to do asylum cases right now, especially when things are going on, but we do have different types of immigration cases. We do sealing and expunctions for those people who have been arrested or convicted of certain crimes, either as a juvenile or as an adult. We handle sealing and expunctions. That's the closest we get to anything criminal related, those and injunctions, but everything we do is civil. Our website is here on YouTube, www.legalaidocba.org, and that's for the Orange County Bar Association. Officially, we're the Legal Aid Society of the Orange County Bar Association, Inc., but we answer to anything. People would say Legal Aid Society, Orange County Legal Aid, that's us. You call us, we'll answer. You go to our website, there's information on there for you. So those are some of the things that we do here at Legal Aid. And if you're not sure if it's something we do, just give us a call and we'll let you know. And if we know of somebody else who could help you other than us, we'll give you their information.
Yeah, so it's a mouthful, Tunisia. And then we've mentioned Harbor House, which is the local domestic violence, intimate partner violence shelter and advocacy organization. Their information is also below, as well as the Victim Services Center of Central Florida. They also provide some advocacy, I know, in some of these cases. So
in Harbor House, the number that you have is their hotline. They'll go directly to them. The first question they'll ask you is, are you safe? And then they'll go from there. So Harbor House has a shelter. They also have the courthouse branch, which I referenced, which is on room 520 on the 5th floor of the courthouse. There they have domestic violence advocates, and they have 4 injunction for protection attorneys there too to help with domestic violence injunctions, dating, and the intimate partner violences. And then they also have outreach locations throughout the county. So if you can't make it to the courthouse, and you can't handle what you need to handle over the phone, they do have outreach locations that are accessible to you. And then Victim Service Center is located over in Orlando too, in downtown Orlando. And they're there to help as well.
And I've tried to put all the information down below. I haven't got any questions, so I don't know if you guys have any final thoughts or words of wisdom to leave us with today. I think that was all the questions I had.
Let me see. I'll go through
my little list. I think either I asked them or you guys have touched on them in one way or the other. So I skipped over a few.
Yeah, I think we've covered it.
Everything.
All right.
So, we can be reached at 407-841-8310. And then you press 0. Because right now we're teleworking, and although we're teleworking, we're still available to you. We're doing a lot of our meetings through Microsoft Teams and Zoom. So even if we're not physically open to the public, we have not stopped working. And we know that with the eviction moratorium that's been going on, that, we're going to get a lot more housing calls once it's over. And we're here. We're here for you. We're here for the residential tenancies, the mobile homes. We've been helping with self-help evictions. Gotten a lot of calls for them, and a lot of calls for divorce. People are realizing being
lots of calls.
I guess when you get stuck together for 6 weeks. And that's part of the reason why we're doing this today, is that we know with the pandemic that people have had to maybe be with their abuser more than normal. They don't have a way to get away. And part of this is we wanted to let you know that not only our office is here for UCF students, but there's also lots of community resources. And, the Legal Aid Society does part of it that our office is unable to do. And trying to give you guys, to let you guys know that we're out there and we want to help in all sorts of different ways. And if you missed it, we had done 2 previous presentations with the Legal Aid Society, one on landlord-tenant. Now that one we did before Governor DeSantis did extend the eviction moratorium through July 1st. But all of that information in there is still good information, except for that part. And then we did 2 weeks ago one on scams, and all of those can be found on our YouTube channel. If you miss them, they're there. You also can subscribe to our channel. That would help us out a lot. We can do more things with YouTube once we have more subscribers. So we'd appreciate that. And thank you for being here today. We really appreciate the Legal Aid Society joining us today. And again, all of the information that we've talked about, the resources, what our offices do, at least to a little bit, all can be found down below in the video description. Thank you, guys.
Thank you for having us.
Thank you.